It is March the 4th, 2011, here in Nashville at the home of Al Knight, a distinguished member of the Nashville and Tennessee legal community. We're conducting an interview as part of the Nashville Bar Association Memorializing Project. I'm Alan Johnson, and before we begin, I want to thank Nashville Media Services and Alan McCoy for donating their time and equipment to come out and film this interview. The Nashville Bar greatly appreciates their contribution. I especially want to thank Al Knight for agreeing, albeit with some arm twisting, to be interviewed. Al, on behalf of the Nashville Bar, we thank you for participating in this project. You and I have had a lot of conversations over the years about your life and career, and it's a real treat for me to be part of this interview so that your experiences can be shared with many other lawyers who have an interest in the history of law practice in Nashville. Now, you began practicing law in Nashville in 1962, is that right?
Well, I began real full-time practice. I was a clerk in the summer of 1961. I was a clerk with Hooker & Hooker.
Okay. Well, we're going to get into that, but first of all, I want to go to get some background and your biography. Your parents are Alfred H. Knight, Jr. and Louise Smith Knight?
That's correct.
And who were your grandparents on your father's side?
Alfred Henderson Knight, period, and Emma Knight.
Okay.
Middle names have flown me. But
okay. And then on your mother's side, who were your grandparents?
Howard Smith and Sarah Smith.
Now, both of your grandparents had interesting careers.
Yes, they did.
What was your paternal grandfather's background and career?
He was one of the four founding partners of Dodge Motor Company. It was a partnership, four-man partnership. My grandfather was the engineer. A man named Zeter, I don't know his first name, was the promotional advertising type guy. John Dodge was the money guy, and I don't know anything about the fourth guy.
Okay. Now, one interesting bit of trivia. Your aunt, your father's sister, married a gentleman who was involved in advertising.
Yes, he was.
And he virtually retired after coming up with a very famous and successful ad that everyone knows, wouldn't you really rather have a Buick?
Yes, he did. Wouldn't you really rather have a Buick than any other kind of car? In case you've forgotten.
Okay, so his father-in-law was part of the Dodge company.
Yes, he was.
Do you have any idea how that went over?
I have no idea. We lived about 400 miles away from there.
Okay. Now tell me about your mother's grandparents.
Grandparents?
Your mother's parents, I'm sorry.
Howard Smith is kind of my hero. Wonderful man, I thought. He died when I was about 7, but I really liked him. And he worked his way through MIT when he was in his 30s, and he became the highway commissioner for New York State by the time he retired. He was a gentle, bright, good guy. I'm very proud to be his grandson.
Sure. Well, you were born in 1937 in Buffalo, New York?
Actually, literally Hamburg, New York, which is a little suburb of Buffalo, but yeah, that's right.
Okay. Well, tell me about your parents. Your father was a retail department store executive?
That's right. He was in he started off as a buyer, and he became a merchandise man, and that occupation moved us about 4 or 5 times as I was growing up.
Okay.
He had one of these fathers that was kind of told him what to do, and he tried to be an engineer, and he was about as good at being an engineer as I would be. I can't nail a nail straight. So he majored in, having not made it in engineering at Cornell, he switched to philosophy And he really, I think, should have been a teacher. He had the instincts and the personality to be a teacher. He wound up in the retail department store business, and he went from city to city with increasingly good jobs until we came to Nashville, and that wasn't quite as good as the job he had before that.
Okay.
But that's I moved several times because of that occupation.
Okay. And your mother didn't work outside the home, but as I recall, she was a very talented lady.
Yes, I mean any talent I have, I kind of trace to my mother. She was very clever, witty, in a low-key sort of way. She loved to write. All she ever wrote were letters. Toward the end of her life, she tried to do other writing. And she said one time, "I don't have anything to write about." And it was kind of sad. She was a stay-at-home mom. She was a World War II mother. And she did have things to write about, but she just didn't think she did. And that was kind of a hard thing for her toward the end, that she didn't get to write.
Sure.
She was very good at it.
Well, I want to ask you about growing up in these various cities, but while we're on the topic of family, I just want to go ahead and get that established. You tell me about your marriage and children.
I was married in 1964 to Lois Chapman.
That was here in Nashville.
In Nashville. I had and have two wonderful sons, Stephen and Eric. Stephen born in 1966, Eric in 1969. Stephen is a lawyer in Nashville, trial lawyer. Eric is a computer, pretty early in the computer business. He was the youngest, they said, the youngest employee of Apple. He was a summer employee of Apple when he was 15. And he went out and worked at Apple and at a spin-off company called B for quite a while, and then he came back here, and he's a home visitation fixer of computers, and that's what he like. He's like me. He doesn't like to work for anybody.
Yeah. Well, sounds like he picked up your grandfather's engineering background.
He definitely, the gene skipped about 2 generations.
Well, then, all right. Then you also married Ruth Sweet after your divorce.
Yes, I did. I married Ruth Sweet in 1987, and she was a wonderful human being. She had 2 children, 2 daughters. I was 50 when we married. I had been dating her since I'd been dating her about 13 to 14 years, and finally we got married. Didn't change our lifestyle much at all. We lived separate, we had separate condominiums. Hers was kind of the home condominium. Mine I would go to work, and when my kids came over, we tended to stay in my condominium. So it was kind of an unusual situation, but it worked pretty well for everybody.
Yeah.
Ruth was a wonderful person, and
Well,
no problem working that out.
I was fortunate enough to know Ruth well, and she was a remarkable lady.
Yes, she was. She was in the theater business.
Mm-hmm.
She worked for children's theater, starting off. She had no particular well, she did eventually acquire education in theater, but she just had a great instinct for it. She was very articulate and smart and uplifting sort of person. And she worked for children's theater when I first met her in 1973. She was making $15,000 a year, and she was bringing in carloads of kids because she had such a great reputation. She asked for a raise to $20,000, and they said no. and she said, "See you later." She went out and started a studio in a kind of a barn of a place, and she just filled that barn up. Then the Performing Arts Center was built. She moved in there, and she had students that went to Broadway and Hollywood, and she was just a wonderful teacher. Then she found out that her students tended to, their ambitions were to do commercials. You know, when it started off, this was going to be Hollywood East. Mm-hmm. We had the movie Nashville, and everybody thought, oh boy, this is great. We got Ruth, and we got all these kids that are going to be great actors, and we're going to export them, or we're going to have a Hollywood here. And of course, that didn't work out. And she had all these students who wanted to do commercials. And so she kind of slacked off that part of it, and she became a voice and articulation teacher. And she, in effect, teaching people how to speak. And she had included in her pupils was Larry Speaks, who was Ronald Reagan's communications director. She had the chairman of the board of the TVA, all the members of the TVA board, the president of the Nashville Gas Company, the dean of the Vanderbilt Law School, several members of the Vanderbilt faculty, and just about anybody else.
Wow.
She was wonderful, wonderful teacher.
Yeah.
Just had a knack for it. She just knew how to do it. Nobody ever taught her. She just knew.
Well, there's no question. I took a seminar from her, and I was amazed at her insight. She could almost read my mind.
Well, I remember what she said to you.
We'll not go into that.
About your brother.
Yes. Okay. Let's get back to your childhood. You said that you moved around because of your father's job. Mm-hmm. Where all did you live?
Well, we started off in Hamburg when I was 2 or 3. We moved to Western Pennsylvania because my father worked for J.N. Adams in a department store in Buffalo. Then he got a job with Gimbel's in Pittsburgh, and so we moved to Western Pennsylvania. First in a little place called Ben Avon for about 1.5 years. And then from the time I was in the 1st grade until I started in the 6th grade, we lived in Glenshaw, which was a very interesting place. It was an old farmland, and our house had been built in 1856, and it was a 3-story house, and it was on the highest part of this area, and it had been the house and then the farmland. And they came in just before and during the war, and they built all these 1-story little houses that they were building in that period. And that was an interesting place. My parents were pretty blue collar about the way they raised me, and I had some friends that taught me a lot about life. I mean, my father made a good salary. None of my friends had fathers that did, really. One of my friends, Bill Lampersky, his proudest boast, and we all were very impressed, he had an uncle who owned a pool hall in Pittsburgh. And that was a really big time. So that's the kind of not a lot of preppies.
Right.
Then my father got a job as president of Rucker Rosenstock Department Store in Petersburg, Virginia, which is 30 miles south of Richmond. It's a fairly affluent, sophisticated little town, about 50,000. And my father was the president. I don't know what really happened but Rucker Rosenstock was the biggest store in a chain called Southern Department Stores. And all I know is Rucker Rosenstock was the biggest earner, and I got impressions from my father's shouting in the evenings that they were spreading the wealth among all the stores, and his store wasn't getting full credit, and he and Hugh Sidner, who was in charge of the Southern Department Stores, were not friends. And the next thing I knew, my father had a wonderful prospect in Nashville, Tennessee, to be a merchandise man for Kane Sloan Department Store.
Okay. But now, while you were in Petersburg, that was during your junior high and high school years? Or?
That was from the from the sixth grade, which was junior high there. It's an 11-year school system.
Okay.
Very odd.
Okay.
6th, 7th, and 8th grade, and then 9th, 10th, and 11th were really high school, except 8th grade was kind of high school.
Okay.
So I finished out high school in Petersburg. Really, my teenage years were spent in Petersburg.
Okay.
And then I went to college, and in my junior year, 1957, my father and the family moved to Nashville.
Okay. Well, very briefly, I don't want to spend a lot of time on it, but you and I have had this conversation about teachers.
Yes.
And you had some incredible teachers
Yeah.
when you were in high school.
I did, yeah.
And one thought that you had, or it's a fact, I don't know, that these were teachers who, because of the Depression, they couldn't get any jobs except teaching in high school or junior high school.
Right.
But they were brilliant and wonderful teachers.
They were among the great teachers I've had. There are two of them I would mention. One is Mr. Sutherland. And Mr. Sutherland had an air about him of just quiet dignity. And the room would be just blowing, the ceiling would be coming off the room before he came in. He walked in and boom, absolute silence. Never raised his voice, cool as the center seat of a cucumber, but they would just settle right down. He had a theory that if you're going to teach, particularly kids, you needed to know something about the world. So every 4 or 5 or 6 years, he'd take a year off and take some other job. And the one I remember is he became a prison guard. And that was just his theory of augmenting his teaching ability. He's the kind of guy,
Very impressive.
unusual kind of fellow.
Yeah.
The other teacher who may have had the greatest impact on my life of anybody outside my family was Mr. Miller, who taught the 11th grade English class, which was the senior year, and it was all poetry. We couldn't read any prose, we couldn't write any prose, so everything we read and wrote was in poetry, and his theory was, and I think he's right, that the essence of good poetry, not the junk you read, but the essence of a great poet or a good poet is conciseness, expressing a truth in the most efficient possible way. And then if you're going to do that, you use metaphors a lot, because a metaphor can say a lot with not many words. And I think I learned to write a whole lot better under Mr. Miller, and that's helped me as a lawyer quite a bit.
There's no question about that. We'll talk about that a little bit later, but there's no question. I wish most of us lawyers had had a teacher like that.
I wish some lawyers I knew had a teacher like that.
Well, while you were in high school, as a kid, I know you had other activities. You ran track, you played golf. Golf is a big thing.
Well, see, I didn't, in high school, we didn't quite make it. I was an avid golfer. Because my parents didn't believe in prep school, I went through Petersburg High School with the boys down on the Cumberland. And my good friend was Dan Moore, and we didn't have a whole lot of, everybody else went off to Episcopal High School or Woodbury Forest or wherever the hell they went, and all these prep schools, and we just kind of got abandoned, and there we were, all these tough guys and us. So we started playing golf, and I got good enough to make the team, and I played a total of 4 matches in 2 years. In college, we organized and moved toward a golf team in high school, but it started the year after we left, so I never did get to play in high school.
Okay.
Track, same. I didn't do any school sports in high school. I did track in college.
Okay.
Again.
Okay. Well, let's move to college. Went to Cornell.
Yep.
Which is where your father and grandfather.
That's right.
And you started Cornell when you were 17 years old?
Yes.
And I can imagine that seems a little young to be moving away from home.
That's a big difference.
Yeah.
The difference between 17 and 18 is major, I think.
Mm-hmm. But you had some wonderful experiences there. Share a little bit of your college experience. You don't have to go into some of the stories we've talked about, as I wouldn't want to share some of mine.
Well, my freshman year was fairly crazy. Cornell is not, it supposedly is an Ivy League school, but it's a Wild West Ivy League school. And I didn't drink significantly in high school. So of course when I got to college, all by myself, I did. And I had a crazy roommate named Jim Quirk, very well named, and we'd be in there working, and about 9 o'clock he'd say, "Time for a study break, roomie," and we'd take off down the hill to Jim's. And I'm just telling you, we had, I don't know what we did, but it was fun because we drank pitchers of whiskey sours with other people, and that's the way Cornell was. It was a rough and tumble place. I don't know how to describe it except generally the parties were the fraternity parties. I joined Sigma Chi. The parties were pretty wild things. I got back from a golf trip one time, walked into the fraternity house at about 2 in the morning, and I couldn't believe it. The floor was just pulsing up and down with people dancing on it. It smelled awful, and it was just a roar. I mean, you couldn't distinguish voices. And I thought, is this what happens? And is this what we do? In my junior year, I was the rushing chairman, and I think the turning point, absolute turning point for me, was when we were in what we called a ding session, and that's when you'd bring up the name of somebody that they'd interviewed to be in the fraternity, and if anybody said ding, he was out.
Okay.
And we thought that was just great, you know. In the middle of a ding session, a guy named Steve Jakobhazy, he was a Hungarian freedom fighter. Wow. That we had taken in. We were going to board him and room and board him, and the school was going to pay for his education. But he had been in that horrible thing in 1956 when they threw rocks at tanks in Hungary, and he fled and came to the United States. And he was in Cornell, and I knew who he was. He walked in, and we were doing this ding session. And I said, "Wait a minute." This guy's a hero. We're idiots. And it was building up, but I just said, I don't want fraternities anymore. I'm through with this. This is silly. Yeah. Childish. So about 2 weeks later, I got up in the chapter meeting, and I told them that I had decided that fraternity was not for me, that I'd gotten a very heavy dose of it as a rushing chairman, and I barely recovered, and I wasn't going to have any more to do with it. And that was thereafter known as Alfie's farewell address. And I went up on the ridge close to the fraternity house with two other guys, both of them crazy, and we rented an apartment, and that's the way I finished out up there. But that was a learning experience.
Oh, yeah, yeah. Well, somewhere along the way, you decided to go to law school.
Yes, I did.
And what prompted that? Did it?
Well, it was a sort of a combination of factors, but it was basically started as a process of elimination.
Well, you didn't have any lawyers in your family.
None.
Didn't know any lawyers.
None that I know of.
Okay.
No. The one thing, my father used to come home at night and complain about his bosses. And I really thought it, frankly, it demeaned him. And I just got so tired of it, and I would say to myself when I was a teenager, just quit. You know, don't come home and complain to us about it. Do something about it. Mm-hmm. And I got a very, very strong mechanism against having a boss. I did not want a boss. And that was about my only criterion. Well, if you look around, I can't be a doctor. You know, I'd kill people. I couldn't be a preacher.
Okay.
I won't comment on that further, but I can't be a preacher. And I couldn't think of anything I could do but be a lawyer, carry my inventory in my head. And so that's essentially, I think, how I came to that conclusion. I think the decisive moment was when they had career day at Petersburg High School, and you went to two sessions that somebody from a business or profession would lead it and talk about it, and you'd ask them questions. So I picked advertising because of my Uncle Mac, and law. Mr. Weich, the DA, did the law thing, and he was very impressive. The advertising session was done by a gentleman named Bobo Bohannon, and he was kind of like his nickname.
Bobo.
I thought a grown man who will permit himself to be called Bobo Bohannon is not my cup of tea. And that really, I will tell you, I thought a business that puts that guy forward is not what I want to do.
Right.
So I think that was the decisive day in my life about going to law school. Now we moved to Nashville, and we happened to have a very good law school right there, and they had Dean Wade was the dean then, and he had a wonderful system that they have since stopped doing. I thought it was a great idea, where he would hire when a professor would retire from some other law school at the age of 65, when he had about 15 or 20 good years left in him. They automatically retired him. Wade would hire him. And I got taught by a lineup of terrific professors. I had Edmund M. Morgan, probably the leading authority on evidence in the country. Warren Seavey, who wrote the Restatement of Restitution. Conflict of Laws. Great guy. Anyway, he was the Restatement of Conflict of Laws, and they were just really, he had really good teachers.
Yeah.
So that was a good place to go and a good choice to make. And also I thought that I probably might want to practice in Nashville, and so if I went to a local law school, I'd make some connections that
Sure.
would get me there.
So you started Vanderbilt Law School in 1959, would that be right?
I started in the fall of 1958.
Okay. You were an editor on the Law Review.
Yeah.
And received an award for a comment that you published on libel.
Yes, I did. Well, the comment, yes, I received the award for the, let me strike that. For the comment was on Lady Chatterley's lover being, whether an idea could be obscene, and that was a comment, which is a shorter piece.
Okay.
I was tied for the note, which is the longer piece, and my note was on libel, and it was a history of a very mixed up, fascinating, confused history of libel per se and libel per quote and special damages and a lot of technical stuff, but it was interesting to see how a huge mistake had been made historically, and they were doing something that didn't make any sense, and they corrected it in about 1980 or so. The Tennessee courts did.
Right.
But that was the note, and I thought my best work.
Yeah.
It came in second.
Well, you graduated third in your class.
Yep.
Who was first and who was second?
Jim Bass Jr. was first. Bob Covington was second.
Well, after graduation, you did not immediately enter law practice.
No.
What happened? Where'd you go?
I was walking down the hall in the law school one day, and the constitutional law professor, Paul Sanders, handed me a letter. It's a letter from Harvard Law School inviting me to be a teaching fellow at Harvard Law School. And I thought it was probably a prank. You know, where did that come from? I didn't know they had teaching fellows, you know. So I walked around. I asked my father, "What do you think?" "Oh, you should interview for it." They didn't ask me to join at that point. They just said interview.
Okay.
"Oh, I think you should interview." So I was going to interview in a Wall Street firm, so I was going to be traveling. So I thought, well, I'll just drop off at Harvard. And I had about 4 interviews. They were terrible interviews. There was a guy named Cavers. I thought he was going to go to sleep. There was a young man named Roger Fisher who used to appear on PBS all the time and talk about negotiation. And our interview was mostly about Roger Fisher. One of the first questions he asked me was, "What is teaching?" And I said, "Gee, I guess I should know the answer to that since I'm applying for a teaching position, but I have no idea." And before I could answer, of course, he was prepared with the answer. And he said, "It's pushing the student, it's showing the student the other side of the pool and pushing him in."
Okay.
And I said, that was right on the tip of my tongue. Anyway, I thought, well, that was a bunch of stuff. You know, I went back, I thought, nothing will come of this. 3 weeks later comes a letter, "We invite you to be a teaching fellow at Harvard Law School." And I thought it was just ridiculous. So we went up there and we spent August preparing the curriculum. There's 6 teaching fellows, and you have 5 seminars a week. There are about 600 first-year students then, 600 first-year students. You had 20 students in each seminar, 5 days a week, 100 students each, 600 total. And we prepared a curriculum that was kind of practical in its approach, like taking a deposition and all that stuff. And then when September came, they introduced us, took us to the faculty meeting and introduced us to the faculty. And they said, this is Stan Johansson. He was #1 at Stanford Law School. And this is Jack Getman. He was in the appellate division of the Labor Department, and all that. And they got to me, and they said, and this is the guy that Eddie Morgan recommended. That was my sole credential.
Well, obviously a recommendation by Eddie Morgan was substantial enough.
Yeah, he was the acting dean of Harvard Law School for a while. He had a little bit, they have a library in Langdale Hall, which is the main hall. Next to the library is a room called the Morgan Room.
Wow.
So that wasn't a bad recommendation.
No, I would think not. Well, you ended up coming back to Nashville to practice law.
Yes, I did.
And how is it that did you apply for a job? How'd you get back here?
I never applied for anything else. When I was at Harvard interviewing, Henry Hooker called the law school, and they had just started a firm called Hooker and Hooker, John Jay and Henry Hooker. And he called the law school. He said, we need an associate who finished #1 in next year's graduate, who's the best student next year's graduating class. And they said, Jim Bass. Oh, well, he'll go to Bass, Berry & Sims. How about #2? Well, that's Bob Covington. We think he's just going to stay here and teach. So there I was, #3. Well, where's he? He's interviewing for a position as a teaching fellow at Harvard Law School. and Henry could hardly imagine that, and me neither. And so he said, tell him to call me when he gets back. So I got back and I had this call slip, and I called Henry. The first thing he ever said to me, when you get finished swinging that tiger you've got by the tail, we want you to come down here and work for us. So it was a pretty quick hire.
Yeah, yeah.
And John Jay wasn't there at the time. He was negotiating tractors for Cuba. In the aftermath of the Bay of Pigs invasion,
yeah,
we were swapping tractors for refugees. John Jay had an in with the Kennedy administration, and he was negotiating.
Okay. So in '62, you started clerking, working?
Yeah, I went to basic training at Lackland Air Force Base for the Air National Guard in August, and then from there to Hooker, and Willis. Bill Willis was now a partner.
I've forgotten that you joined the Air National Guard.
I did. Yeah. I could have waited. I had a good friend who I won't name, who got to the age of 26 by various means without being drafted. They were drafting. And I could have done that by taking a teaching job. But they called it assistant dean at Vanderbilt, but it was very administrative and wasn't a big job. But I decided I'd be very patriotic and I would get in the Air National Guard. And about a year after I got in, I realized that there was a substantial likelihood that we would be going to Vietnam. So much for patriotism.
That's right.
But the basic training was tough.
Yeah.
And good thing.
Yeah.
So that was quite a year. I had, by the way, at Harvard, my second term, I taught the first term. The second term, I was a research assistant for Charlie Harr, who was a real character. And Charlie had a project.
Now, Charlie Harr was a major expert on land use.
Land use planning.
Okay.
Maybe first in the country at that. I don't. Everybody up there said he was. And he was a real character and a good guy. And what he wanted me to do was, there was a state standard zoning enabling act, and it had a provision that said zoning shall be in accordance with a comprehensive plan. Nobody knew what that meant. Some cases said, well, you have to have a master plan and do that. Some people said, no, no, no. You just have to be able to look at the zoning and see a pattern. And so Har said, well, we're going to solve this problem. Said, we're going to have you read every case on the comprehensive plan requirement in New Jersey, Connecticut, and Maryland. You will then extract the factors that affected the decision, and you will weight them in terms of how much effect they had on the decision. And then it will take all of your research, we'll put it together, and we'll have these weighted factors. And he said we can apply them to any case, and we'll know whether we had an honest judge.
Okay.
I spent the first week writing a memo to Charlie on why this was a totally ridiculous idea. And he was a real character, and he read it. He had a cigar, and he read it, and he would read a page and throw it kind of on the floor. He'd read another page. Went through the whole 8 or 10 pages. And he said, well, you make some good points, but suppose we do it, and the New York Times picks it up. What could it hurt? So that was Charlie, and the New York Times did not pick it up, and it was a mess.
Oh, well, gave you something to do at
Yeah,
Harvard.
and I had all these footnotes, and when I left Harvard, I had not completed the footnotes. And it took me another month and a half to complete the footnotes. And I finally got a message from Charlie, and he said, I'm awaiting your footnotes, which will presumably be arriving on a truck.
Which is why it took you a month and a half to complete the footnotes.
So I started that year with Charlie. I went to the Hooker and Willis for a short period. Went to basic training at Lackland Air Force Base, which is a well-named place. Lackland, you got it. And then started practice. So that was probably one of the busier years of my life.
Sounds like it. Sounds
God.
like it.
Yeah, it was. It was great.
Just for purposes of rounding out without getting into detail, I want to come back to the detail. You were at Hooker and Willis, and then you left there and went to the U.S. Attorney's Office as an assistant U.S. attorney.
Gil Merritt was my friend and roommate at Harvard. He was taking a graduate degree in law, and we roomed together in the attic of Mark DeWolf Howe, who was a professor at Harvard and was writing a biography of Oliver Wendell Holmes. And he became U.S. Attorney in 1966, and he invited me. He got, I don't know, it's a complicated system, but he gets to name a certain number of, he named me his first assistant, which was kind of a neat job. And I started in September of '66, and I went through May of '69 when Nixon won and everybody got dumped out.
Okay.
That was back. It used to be that if the administration would change, all the assistant U.S. attorneys would get dumped. They changed that a few years ago, and these assistants stay on, which I think is a bad idea. I think they become professional prosecutors, and I think it was better when the prosecutors were just another Nashville lawyer who had the different side of the case. I think it went a lot better, and they didn't become cops, you know.
Sure,
It was
sure.
better. I like the system better, but
Well, then, and I'm coming back to all this, but then after he left the U.S. Attorney's Office, was Hooker and Willis still in existence, or what was the status?
No, it was not still in existence. John Jay ran for governor in '66, ran again in '70. I helped a little bit in that campaign. Ran in the general election in '70 against Winfield Dunn, and was beaten. And he was out of practice. He just didn't. He wasn't a lawyer anymore.
Yeah.
I mean, he's messed around ever since, but.
Yeah.
And I don't know. I'm not sure what Henry. I think Henry State did some kind of practice. I don't know what he did. I kind of lost track of him. So when I came back, we formed the firm of Willis, Knight, Chambers, and Barr.
Because that was Bill Willis, you, John Chambers, and Bill Barr.
Bill Barr, and Chambers and Barr were two guys who had become associates in Hooker and Willis while I was in the U.S. Attorney's Office.
Okay. All right. I'm going to back up a little bit. The first period with Hooker and Willis, that 4 years or so. What was your first assignment when you started working there?
Well, my first assignment was in the summer of '61 when I was just a clerk, I think.
Okay.
I may have the year wrong, but I think that's right. And I think what I did was write a brief for John Jay, who was representing Clifford Allen, who was a professional, I'm going to get in every political race in town guy, and he finally made Congress, beat Merritt, among other people, to become a congressman in '75. But he was always filing suits and making the paper by doing. And he hired John Jay to file a brief affirming the constitutionality of metropolitan government. I'm not sure that the lawyers that had the case really needed his help. And coincidentally, they had Merritt writing their brief. and Merritt, it was a Waller firm, and Merritt wrote the brief, wrote every line, and nowhere, the only thing that's missing from that brief is his name.
Okay.
I wrote a brief for John Jay. I'd had about 10 days after I got back from basic training. And he said he had found a sentence in a 1926 Tennessee case. It was something like Republican constitutional government.
Okay.
And he said he wanted me to base the argument on that.
That was the extent of his guidance.
That was about it. So I went off, and I was dumb enough to try to do it for a while, and then I said no. So I just wrote a standard brief. I mean, I just wrote a sane brief about it. And I didn't get it to him until the morning he was going to argue. We sat in Stum's, and he kind of looked like Charlie Harhead reading my paper up there. You know. And he said, well, if you're going to write that kind of brief about Republican constitutional government, you might as well not write a brief about Republican constitutional government at all. And I said, yeah. So he went up and made I have never seen a guy, he was gifted. People don't understand how gifted he is. But he was up there, he made this amazing speech, and he paced up and down, and he'd walk toward the lectern and back and and he made, I don't know what he said, but it sounded like he was right, and he was sure emphatic. And then he wrote the brief. It was a terrible brief, and he signed my name to it.
Oh.
Along with his.
Okay.
It was fine with me, you know.
Yeah, sure.
So Merritt, who wrote the real brief, was zeroed out, and I, who didn't write a brief, was credited with this monstrosity that Hooker wrote. And that's kind of the way it was, you know. Those firms, I made more than Merritt. I made $350 a month. Merritt made $300. And he wrote the damn brief.
And had a master's in law from Harvard.
Had a master's in law from Harvard Law School, yeah.
Of course, you'd been the teaching fellow.
I had been a teaching fellow.
What kind of hours did you work?
I worked a lot of hours because I was the researcher. Hooker once referred to Willis as a factor. He said, "You're not a lawyer, you're a factor." And both John Jay and Henry were factors. They were wonderful with juries. They were great at presenting facts, arguing facts, but they had an allergy to the library. So I literally did, I think, almost all the research for that firm, and they had some big cases.
Yeah.
I mean, they started representing the Tennessean, and they had, some very fundamental big cases. So that's what I was doing mostly. And then the other part of my practice was taking the crummiest General Sessions Court cases they could find, and I got to do those too.
That sounds familiar.
Yeah. Yeah. We had a fellow named Brown Taylor who was famous, I think. I don't know if he's still famous, but
General Sessions Judge Brown Taylor.
Generally known as the worst judge ever, in the southeastern United States, I guess, at least. I was arguing a case one time, and he started as I started my argument, he started writing out the judgment on the warrant as I was arguing the case. And I stopped. And he said, "No, go ahead. Fine argument, young man, fine argument." And he forced me to continue arguing the case when we both knew he was deciding it against me, even as I argued. And that's about what went on. It was just amazingly bad. I think it was worse then than it's ever been since, in that sense.
Yeah.
Oof.
Well, there was a story that you told me once about you and Tom Higgins back in that period of time, and Judge Brown Taylor. A few years ago, I bumped into Judge Higgins, and I asked him about it. And he said, "I don't remember it specifically, but it sounds like something I would have done."
It's something he did do.
and that involved Judge Taylor would take cases under advisement.
Yes, he would.
And you didn't want to ask him about it.
His garage was full of cases that had been taken under advisement in the rafters,
But if you asked him about it, he would rule against you.
He said, "I've decided against you."
But in this particular instance, you and Tom Higgins had a case under advisement, and what did Judge Higgins do?
Well, he'd had it for about 3 weeks, and so finally Tom went to him, and he said, "Judge, Al Knight wants to know what you did with that case we had last week." And Taylor said, "Well, you can tell him I decided it against him."
Well, during that period of time, you mentioned the firm was representing the Tennessean, and of course you had written a very good note on libel, and a very substantial libel case was filed against the Tennessean that you helped with.
Yes, it was. It's the last time the Tennessean's gone to trial on a libel case. January 1964.
That was McNabb versus the Tennessean. He was a political.
Earl McNabb was the chairman of the Democratic Nomination Commission.
Okay.
And there was a guy, a Second Ward, Paul, named Gene Little Evil Jacobs. He was named Little Evil because his opponent had been, well, he was a son-in-law of some politician, and he was running against another guy of equal quality. And some Tennessean reporter asked Jacob's father-in-law, I don't know, somebody got asked. Maybe the Tennessean reporter asked the father-in-law of Jacobs, yes, who the better candidate was. And the guy said, well, of the two, I would say that Gene is the lesser of the two evils. And thereafter, every time they referred to Jacobs, they would refer to him as Gene, little evil, Jacobs. And he actually got prosecuted because he would forge the names of voters on absentee ballots.
Wow.
And he voted about 2,000 people by that method. And that was Carlton Loser and guy that was our mayor. We all know him.
Mayor Briley, Mayor. I'm sorry, Al.
Became a congressman.
Fulton.
Who?
Dick Fulton.
Fulton.
Okay.
Fulton and Loser.
Okay.
And Little Evil fixed that, and then they re-ran the election, and Fulton was elected.
Okay. Well, that case, and this gets back a little bit to Hooker, and Willis. From what I have learned, either from you or Bill Willis, or I don't know. Of course, John Jay and Henry Hooker's father was extremely prominent, brilliant trial lawyer.
The South's finest trial lawyer.
Henry Hooker Sr. And
John J. Hooker Sr.
Okay. But John Jay and Henry didn't want to go work for their father.
They tried it. John Jay tried it briefly and left.
Okay. So they're the Young Turks starting out their own little law firm.
Right.
And they pick up the Tennessean with Eamon Evans and John Sigenthaler, who they know. And the big firm, at the time big, still big, Waller Lansden, represented Earl McNabb and sued the Tennessean for libel.
Right.
And all eyes are on the Hookers to see how well they're going to do defending against this big firm in a very significant case at the time.
And they're all sure he'll fail.
Right.
They think he's full of hot air.
Yep. And needless to say, he did not fail. And from what you told me, he made one of the most incredible jury speeches.
He was the Clarence Darrow of the 60s, I'll tell you. One of the great misfortunes I've witnessed is the fact that he didn't stay in the practice of law. He was a marvelously talented, extemporaneous speaker. I've never heard anything like it. And they went to trial, against Earl McNabb, and William Waller and Dick Lansden went to court for probably the second time in their careers. And Hooker and Willis beat them.
Yeah.
And Hooker performed, the whole bar, it looked like, was lined up around the wall of the courtroom. And Hooker made his final argument. And the one thing I remember about it was there was some fact that Earl McNabb was complaining about that the Tennessean didn't publish, but it was a fact that Earl knew about, but he never revealed. And in the middle of his argument, Hooker turned to McNabb, who was sitting at the counsel table, and said, "Why didn't you tell us, Earl? Why didn't you tell us?" And I thought, gee, I've never seen a lawyer do that before. But they won.
Yeah.
And about that time, New York Times versus Sullivan got decided.
Which changed the landscape of libel law forever.
Absolutely. It said that that a public official could recover in a libel case only if there were false defamatory statements made about him that were made either with knowledge of their falsity or reckless disregard of their truth. So I just kind of blithely briefed that. I had that brief out a few days ago. It's legal pad, and it's 86 pages long. And the first 3 pages say, if you want to apply New York Times versus Sullivan, you can decide this case by reading these 3 pages. If you'd rather not do that, and then of course decided for us. If you don't, rather not do that, here are 83 pages. Miasma of common law, procedural, and substantive rules. Just take your pick.
Okay.
So we got an opinion affirming the case in which the courts somewhat dishonestly said, well, we have some problems with this from a common law perspective, but we won't go into those now. We'll just decide it on the case of on the basis of the Sullivan case.
Okay. We took a short break, and in the interim, we dug out the brief that Mr. Knight was just talking about. Hold that up for the camera, Al. That was the appellate brief in the McNabb lawsuit.
87 pages.
87 pages, and it's covered on the front with scribbling by John J. Hooker, who
Yes, it is.
used that, I presume, in his oral argument.
I presume.
That's a piece of...
It says work file copy of JJHJR. Yep.
Okay. Well, let's move to the U.S. Attorney's Office. You were the first assistant under U.S. Attorney Gil Merritt. Roughly how many cases did you prosecute? Let's say you were there from 66 to 69.
Yeah, I was there from September of 66 to June of 69. And I prosecuted a lot. One of the main reasons being that we did still cases. We did illegal still cases.
A lot of moonshine floating around back there.
Moonshine cases, and mostly in Columbia and Cookeville. So I might try 8 or 9 jury cases in 2 weeks. I mean, they just boom, 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 boom.
Yeah. Now you had a very interesting experience in Cookeville, as I recall. You wanted to conduct individual voir dire of the jurors because you knew that you had a guy who was a snitch, and that gave you some problems about how they might view his testimony. I think that was the issue. I don't recall exactly.
I'm trying to remember what the issue was. I think that what I did was I didn't want to try it in Putnam County.
Right.
Because it was a police brutality case. And that was in the late 60s, and police brutality was whining about police brutality was not a popular thing with country folks.
Okay.
So I wanted to get that case back to Nashville. So I questioned the jurors individually.
Okay.
About what they thought about, and I gave them a somewhat colored description of what had happened. And do you think policemen ought to be prosecuted for that? And I did that for about 2 hours, and I had one juror that was qualified. The rest of them. So Judge Miller, at the end of the day, I did it all day. At the end of the day, he said, we will reconvene in the morning. I'd gone through the whole jury panel. He said, we will get people from off the street, and I will ask the questions. So he asked all these legalese questions, and they all said, nothing. So we tried it, got a hung jury, and then we tried it again about 2 weeks later, and they convicted these thugs, and they really were thugs. It was the big sheriff, the high sheriff, the big sheriff, and the little sheriff, or something, or the big deputy and the little deputy. And I've got pictures of them next door here. And they're really mean-looking people, and they beat up these truck drivers for nothing.
Okay.
And I did get them convicted the second time around, and it kind of reaffirmed my faith in the jury system.
Yeah.
I mean, that's about the last time I thought I was smarter than the jury. And we played that second one very straight, and they just went out and came back and convicted them.
Wow.
I remember in the voir dire in the first case, a guy named Roberts, who was a local lawyer, he voir dired the jury. This must have been a different case. This must have been a Tennessean case. And he said, would it change your view of this case if you knew that John Siegenthaler, the editor of the Tennessean, had attended Martin Luther King's funeral? He asked that in Putnam County.
Okay.
And that's the kind of stuff you got back then.
Yeah.
But that was a different case.
Yeah. Well, I would love to talk about a lot of those prosecutions. Some of the moonshine cases were fascinating. I think you told me stories about Jerry McCauley down in Columbia. And,
who was impossible to beat.
and the fellas, the defendant always looking for a pig, and they caught him by somebody else's still.
For a pig. We got one defendant who was looking for a pig twice. And we tried the case. He testified that he was out there looking for his pig, and he came across his still, and he sampled the brew. And that's when the revenuers came popping out of the bushes.
Just a remarkable coincidence.
Yeah. So he was acquitted, of course. And then we were trying the second time, and he had the pig defense again. And we took a recess. We were sitting in Judge Gray's office. And I said, well, Your Honor, he's going to do the pig defense again. This time he's going to use his wife. His wife's going to say he was looking for a pig. And he thinks that'll keep me from proving that he said the same thing last time. Of course it won't. And Carl said, well, sure, of course it does. That's not admissible. And Gray said, perfectly admissible, perfectly admissible.
I think I misspoke. That was Jerry Cawley.
Jerry Cawley. What did I say?
I think I said Jerry McCauley, but it was Jerry Cawley.
Jerry Cawley,
yeah. Very good lawyer from Columbia.
Wonderful lawyer.
Good guy.
Particularly in Columbia.
Yes, yes. Who were some of the other lawyers that you worked against while you were prosecuting? Too many of them. It's been a long time.
Yeah. You know, it's funny how you remember people when you don't remember their darn names. Names are the first to go.
Yeah. Well, let's talk about one of your biggest cases. Was the Etheridge trial that you and Judge Merritt tried for 6 weeks.
Yeah.
And Etheridge was the leader of a bank robbery gang, and there was some involved murder and very interesting evidentiary issues that you all had to tackle.
Bill Wilson was in that case. And my nemesis, who in the world am I thinking of? Bald guy.
Dale Quillen.
Dale Quillen.
He's
still practicing, I think.
Yes, and Mr. Quillen had a very extensive criminal defense practice.
Yes, he did. Well, he has nothing else, does he?
I think that was about it.
Yeah, well, Quillen and I met about every other time I went out. And the Etheridge case, Bill Wilson represented Etheridge. And that was some case. That took about 2 months to try, and they had murdered one of the gang because they thought he was going to snitch. And so the murder, the trick in that case was getting the murder tried in federal court. We had been, and the FBI had been researching this bank robbery ring that was robbing every bank in Tennessee. And what they would do is they would steal a car from some respectable citizen. They would drive it to the bank. They'd rob the bank. They'd drive the car out of town about 2 miles. They would abandon it, get into their own car, and take off. And it was very hard to trace them. And that got to be the standard way of doing it. And I had one of my favorite cases when a fellow named Roy Richardson robbed a bank in Lewisburg. And when I tried it, he had done this same thing, that same
Stolen
method
a
at
car
the
and then gone somewhere else.
And I had a farmer. You always get farmers for witnesses. And he said that we proved what went on at the bank, and then he said, and then they got out there, and I saw this, all I saw was this car drive out and stop, and these guys got out of the car with these boxes in their hands, cartons or whatever they were, and they got into Roy Richardson's truck. And I just left it at that. And the defense lawyer, who was a wonderful defense lawyer from Alabama, got up and he said, "Well, do you know Roy Richardson?" And the guy said, "No, I don't." And he said, "Well, how did you know this was Roy Richardson's truck?" And he said, "It said Roy Richardson along the side." And when this guy, wonderful guy, walked out of the courtroom, he looked at me and he said, "I've been disemboweled before, but seldom so adroitly." Those bank robbery cases were something.
I bet. Now, the judges, federal court judges, were Judge Miller and Judge Gray.
Right.
And what were they like?
Well, Judge Gray was a feisty guy. He was kind of my ally. He was kind of pro-conviction. He wasn't dishonest about it, but he would bark at the defense lawyer and, you know, kind of help out. And really nice guy, good guy, honest guy. But then he was very decent on sentence. He was not a tough sentencer. Miller was the reverse.
Okay.
Miller was a scholarly, very nice guy during the trial, and then after the trial was over, if they were convicted, he'd absolutely kill them. I had a case one time where I had a case in Judge Gray's court, and I was using somebody that had been convicted in Judge Miller's court. He'd been convicted in Judge Miller's court of selling marijuana, which is the least harmful of the drugs. He got 5 years, I think. We went over to Gray's court, and the charges there were cocaine sale, which was far more serious. I mean, that was a serious thing to get people into. He was my witness because he was convicted and he was trying to get some credit for doing it. He testified against them. And he got something, and they got something like 18 months.
Wow. And
this guy says, "I get 5 years for marijuana and they get 18 months for cocaine?"
A legitimate question.
Well, you're in the wrong court, buddy.
That's right.
Yeah.
Well, okay, you said when you left the U.S. Attorney's Office, you went to form the law firm of Willis, Knight, Chambers, and Barr.
Right.
And then that name evolved over the few years and finally became, within a few short years, Willis and Knight.
About 1975 or 6, it became Willis and Knight, yeah.
And a lot of lawyers
What?
A lot of lawyers have worked in that firm in some capacity over the years. Can you think of some of the names, or can I rattle some off and get some thoughts about them?
Oh.
Well, I know that Bob Brandt was a law clerk there.
Bob Brandt was a wonderful clerk for us and went on to become a very good judge.
Right, Chancellor Brandt.
Right. Jack Waddy.
Jack Waddy.
Jack Waddy was a wonderful associate, and the good ones leave because they form their own firms.
Mm-hmm.
The bad ones get fired, the good ones leave because it's really hard to build a small firm.
Yeah.
He now has, did have, I'm sure he still has the best and one of the only firms in Nashville that specialize in intellectual property.
Right, probably one of the best intellectual property firms in Tennessee, I would think.
I would think so. He's very able, capable guy.
Marion Harrison came in as an associate, became a partner, and Marion is now a bankruptcy court judge.
Yeah, I think in '99.
I think that's right.
I was on the committee that nominated her.
Mm-hmm.
I couldn't vote
on
her case, but we'd nominate 3 people, and then one would get selected by the judges.
Dick Lodge was. Dick came in about the time Marion did, in the mid to late '70s, and then he was snatched up by Bassberry and Sims.
Yeah, well, he became, while he was still with us, he became the chairman of the Democratic Committee.
Right.
For Tennessee.
Right. Yeah.
And he was an associate in our firm.
Yeah.
Something tells me we didn't promote him fast.
That's probably the case. During the years of Willis and Knight, you mentioned that John Jay ran for governor in 1970, and what, Bill Willis, his campaign manager?
Yes.
And that left you and the rest of the guys back at the firm to...
It left us out working for Hooker in the North Nashville, is what it did.
Then you also, didn't you manage Judge Merritt's campaign in 1975 for U.S. Congress? Mismanaged.
I was not a good campaign manager. He was a little too intellectual and straightforward to be a good political candidate, and I was worse as a campaign manager. And we spent, I don't mean to cut you off, Alan,
that's okay.
We spent several weeks trying to force Clifford Allen was his big opponent, tried to force him into a debate, a TV debate. We would hide behind the pillars on the 6th floor of the courthouse and leap out at him with a color vision camera. Why won't you debate, Mr. Allen? You know. And finally he did debate. And Merritt delivered a thoughtful, thought-provoking, wonderful speech. Clifford got up and said, "Thank you for giving me credit for having no sense at all." And that was the tone of his speech. And he creamed Merritt, because fairness is not at the center of effective political speaking. And he really demolished Gill. We'd said all along that it was a 2-man race between him and Clifford.
Okay.
There were 4 candidates.
Okay.
Merritt finished 4th.
Oh.
And on election eve, they were swarming around the Radisson Hotel, the cameras and the reporters, and they said, "Gee, you said that it's a 2-man race, and Merritt has only 814 votes, and Allen has 8,619. And I said, "Well, we don't know where those votes are coming from." Then I got in my car and went home and unplugged my phone.
A wise move, no doubt.
But Merritt went on to an illustrious career he finally became the chief judge of the 6th Circuit Court of Appeals in Cincinnati, and I think it's a good thing. I think that was good for him that he lost the congressional race and got to be a judge. That was a better job for him.
Well, you had quite a few major clients and cases during that firm, Tennessee and Gannett, of course. Service merchandise for a while. Johnston & Higgins, an insurance broker.
Yep. Federal
Express. Simon & Schuster.
Yeah.
Various other media outlets that if they had some libel issue, get sued in Nashville, they would hire you. The firm represented Metro School Board. And
we got in the Blanton case.
That's right, Ed
Governor
Hood.
Blanton's criminal prosecution.
Right.
And I appealed. Ed Hood, one of the finest people I've ever met, got caught up in all that anti-Blanton feeling and got prosecuted for no reason at all. And for the first time in the history of the Anglo-American legal system, the prospective jurors were not permitted to be asked what their opinion of the defendants were and what they thought about the defendants. The judge said, no, we can't get into that.
Notwithstanding the massive amounts of publicity.
Well, because of the massive publicity, Judge Peck thought we'd never get a jury if we'd start asking them how they feel about these guys. So he cut all questions off. I appealed that to the Sixth Circuit. A very conservative judge named Engel from Michigan. I made the statement that we were not permitted to ask a single question. Bill Willis was not permitted to ask a single question about the jurors' knowledge or opinion of the defendants. And I have never seen a judge so stunned in my life. You mean they couldn't ask them anything? I mean, in the 14th century you could ask it, you know.
Yeah.
Good gosh. So they reversed it. And then they decided they'd have an in-bank rehearing. And George Edwards, former police commissioner from Detroit, and a real hawk,
Yep.
led the charge, and they took the case. Merritt couldn't sit on it because he had been an advisor to Blanton, so he kept me informed. And he said, well, it looks all right. And they, no, it doesn't look too good. Oh, it looks like Edwards is forming a coalition. And finally, it was 9-4, affirming the conviction. And they said, in the opinion, exactly what was said in Bush versus Gore, which was, this is a unique case and should never be cited.
Wow. Wow.
And that's just especially for you, Governor. Nobody else gets this crap. And I still don't know how they possibly affirmed it, but all I did was argue and brief it. I've got no idea how they did it.
Sure.
What they did.
Well, there were several other cases. We could talk about them all day long.
Yeah.
I just want to touch on a few.
Okay.
And I'm just kind of side them off a little bit. This was probably back with Hooker and Willis, the Kovich versus Maddox.
Very definitely. That's about 1965, I
right.
think.
And that was when the state Senate barred the Tennessean from reporters going on the Senate floor to cover the proceedings.
Yeah, they put them back in the audience section.
Right.
And it's sort of a unique case because it doesn't involve locking anybody out.
Mm-hmm.
And it's the only case I know of that involves exclusion from a legislative body. But we won that case.
Yeah.
In the federal district court.
Right. In the early 80s, you had a case for the Tennessean State versus Drake, in which you established or helped establish a rule that trial courts have to follow when the defendant wants to close a portion or all of a trial to the public.
Well, that specifically had to do with closing preliminary hearings.
Okay.
The court finally, after 13 years of struggle, the Supreme Court decided that there was a constitutional right to attend public trials.
Right.
This was a preliminary hearing.
And that might involve something like a motion to suppress evidence, which if that got out in the public, obviously could be damaging to the defendant.
Absolutely.
Yeah.
And so the public interest in seeing it was less, and the possible harm was greater. And so that was not an easy case, except that while it was pending, the Supreme Court of the United States did a lot of mumbling in the background and decided a lot of other cases that came fairly close to it, so that I was pretty confident when I made the argument. And you were there as a clerk.
That's right.
In the Supreme Court, and the chief judge just kind of took dictation. I mean,
Judge Phones would almost stop you every minute, say, wait a minute, and
right,
keep writing.
Once you get that, yeah.
That's right.
And I had a sneaking suspicion that I had probably won the case. But what we produced out of it was kind of a monstrosity. If you've ever read it, it's about several paragraphs of detailed instructions about what you have to do when you have a preliminary hearing in a criminal case,
right,
in terms of the press. And that's my doing, and I'm not sure that's the best thing to do. But
well, one footnote, I think I've told you this, but I was working as the clerk for Frank Growota during that time, and Judge Phone's secretary was down the hall, and she told me that she was finishing up that opinion, and she noticed that Judge Phones had not dictated opinion over the top of it. And she said, Judge Phones, shouldn't I put opinion? And he paused for a moment and said, well, I guess, but it's really just a rule, which it was.
I think he used a little expletive in there, didn't he?
I think so.
In the first version you told me.
Yes, well, that would be Judge Phones.
Yeah.
Okay, boy. Oh, can't leave this one out. I know that with Willis and Knight in the 70s, you got a lot of court-appointed cases to defend. I think Judge Gray would always send kidnapping cases to you.
No, that would be Judge Morton.
Judge Morton, okay.
He specialized in giving me bad. He and later Judge Higgins. As an aside, I might say that Gil Merritt, who was on the Sixth Circuit at the time, said that his brethren thought I was the best appellate lawyer in the Sixth Circuit, which is, Michigan, Ohio, Tennessee, and Kentucky, which was preposterous. And I said, Merritt, I've got a secret for you. I get a lot of reversals. It's not because I'm a great lawyer. It's because I really, really get screwed by Judge Morton and Judge Higgins. They're very creative about it. They're nice guys. We're friendly. But they love to figure out ways to rule against me.
Well, I have been told by a couple of appellate court judges in the state of Tennessee that you're one of, if not the best appellate lawyers in the state.
Well, thank you, Alan. I'm glad to put that. Did you get that? Okay.
Well, speaking of appointments, we talked about this afternoon. You were appointed to a case in the Sixth Circuit by your good friend Gil Merritt, and
yes, I was.
As you told it to me just a little while ago, it was somewhat fortuitous. You had called him about something totally different, and he said, well, forget that, by the way.
Yes,
I think I'll appoint you to this case.
Yes.
And it was a very awful prosecution of a former judge from Dyersburg, Judge Lanier.
Yeah.
And
my daughter-in-law is from Dyersburg, and she is quite ashamed of me for having represented him.
Yes, yes. Well, Judge Lanier was prosecuted for
fondling women.
Fondling women who were possibly litigants in his case court.
Well, no, they weren't. See, that's the point. None of them really had anything to do with any case he directly was dealing with. They were courthouse visitors of various kinds. They were there on all kinds of different errands. And none of them had any direct involvement in any case he was handling.
And there's probably no question under the facts, Judge Lanier was guilty of state criminal laws of sexual assault.
No doubt.
But the issue here, he was prosecuted in federal court
because he owned Dyersburg, and the state people were not going to prosecute him.
Right. And in federal court, they said that he had violated a statute that made it illegal to act under color of law.
Section 242, 18 U.S.C. 242. Right. If you violate somebody's due process of law while acting under color of law.
And that was really the narrow issue for you, The Sixth Circuit reversed his conviction, and then
well, having appointed me, Merritt led the charge to reverse the conviction. I think he had that in mind all along.
okay.
Yeah.
Well, but then after the three-panel opinion came down, it was not unlike the Blanton case. They decided to have an en-banc hearing and reversed the three-panel opinion.
Well, the three-panel affirmed the conviction.
Okay.
Then the 13 judges on the en-banc reversed the conviction.
That's what happened.
9-4, but they did it, I thought, on the wrong ground. They said it's not a violation of due process of law just to fondle a woman who happens to be a visitor just because the guy happens to be a judge. That has nothing to do with due process of law. I thought the easiest argument, the clearest argument, was to say if he wasn't acting as a judge, it wasn't done under color of law. And that's the way I framed it. And the Sixth Circuit opinion was talking about due process, which is a ghost. I mean, what is that? And I think it's easy to make the other argument. So that's what I was emphasizing. And the Deputy Solicitor General, who was on the other side, said, Mr. Knight is arguing this color of law issue, and it has never been ruled on. And Scalia, in his usual manner, said, oh, that's dirty pool. He's raised it every chance he's gotten. And the Deputy Attorney General said, Your Honor, we never play dirty pool. And I knew I was in their playground, you know, I mean, what the hell. Anyway, they remanded it. They said they were troubled by it, but not enough to reverse it, and they knocked it back to the Sixth Circuit.
Okay. Sorry.
Hello?
I was bringing his stuff back. I'm sorry.
No, that's fine.
Can I go
You
ahead
can.
and bring it back real quick?
Just turn
Yeah,
that off
sure.
for a second.
I apologize. I'm sorry.
Okay.
I didn't realize
Well,
you
no,
guys were still
you
here.
just
Well,
don't
this is all
apologize for
blocked
doing
up.
your
Just gonna
job.
Set that in the chair. We'll
Oh, okay.
get it taken care of.
Sorry, folks.
You didn't know.
Don't apologize.
That's
See you
okay.
later.
So,
All right. Well, we can go on these cases because they're so fascinating, and I fortunately got to work on a lot of cases with you, which was a great learning experience for me. But I want to ask you, get away from some of our war stories. You did a lot of other stuff besides just practicing law. You were, I forgot the name of it, was a land condemnation panel for TVA back in the 70s. I believe
yeah, what we did was when there'd be a condemnation, if there was a dispute about the valuation of the property, we would value the property.
Okay.
And basically what we did, there were three of us, what we did was take the owner's valuation if we possibly could justify it, because the TVA just had all these studies, and they used the same ones in case after case, and you know, it wasn't really evidence. We got so sick of listening to it. And these poor landowners would come in, and their barber would say, oh, I think that property is worth about $1,000 an acre, and he wasn't an expert, but we'd let that in, and we did everything we could to give them something decent.
Yeah.
And they still didn't do, you know, it was still too low.
Yeah. And that was the other panelists were Charlie Trost from Nashville and Billy Jack from Columbia.
Well, it was Charlie Trost, Billy Jack, and Fred Elledge.
That's
there were
right.
three of them, and they rotated a little bit.
Okay. 1976 Tennessee Judicial Council.
Yeah, that's something I did very little on. We issued a couple of reprimands, but I don't remember any facts or any names connected with that. That is a lawyer body that criticizes and can penalize judges.
Okay.
And we never did much with that.
Okay. 1980s and 90s, you were on the drafting committees for the Tennessee Rules of Evidence and amendments to the Tennessee Rules of Civil Procedure.
Tennessee Rules of Evidence was the most interesting, useful thing I think I've ever done as a lawyer. Tennessee did not have a code of evidence, and we did one from the ground up. We used the federal code. Don Payne, who you know, is just kind of Mr. Tennessee law, and he would come in as our reporter, and he would say, well, here's the Tennessee case law tends to say this, but it doesn't say that. Then we'd look at the federal rules of evidence, and then we had 9 lawyers, 3 from each section of Tennessee, and we had wonderful debates on the rules. And I will tell you that we didn't just adopt rules. We really, everybody on that panel had tried a ton of cases, and those rules are our best effort to get good rules of evidence. And they're not all the same as the federal rules or the previous state rules. They're kind of an amalgamation. Some of the federal rules, for example, give the court absolute discretion to admit hearsay if the court thinks it has the same reliability as something that would be subject to a hearsay exception. Well, that's not a rule. That's just putting the goat in charge of the garden, you know. So anyway, I just loved that, and the civil procedure business was interesting too.
And those committees that lasted for a while. Obviously, that was a huge project. So you're talking about 2 or 3 years or so.
Oh yeah,
work.
Sure. A lot of fun.
Yeah. You're also in the 90s. You mentioned earlier, but you were on the advisory selection committee for selection of the U.S. magistrate and U.S. bankruptcy judge.
That was very interesting.
I bet.
And we'd get a huge number of applications. And the first thing was to decide who got to be interviewed. And when you decided that, you wound up with about less than 1/10 of the total applications. I mean, most of the people we didn't think were worth interviewing. We would then interview them, and we really did. I'm proud of that committee, both committees, because we really did try to pick people. There were no politics involved in that. We really did try to pick the people we thought would do the best job. I don't know that we did or not succeeded, but that was definitely the focus. Mm-hmm. And one of the most tiresome parts of the process was getting rid of all these applications that were clearly not going to be granted. And we had some fights on some of those, but you had to do that first, and then the more interesting part of it was when you got down to 8 or 9 people, and those are the people you interviewed and really got serious about. Yeah.
Of course, this was a group of lawyers from Nashville and mid-state area who knew the applicants and had some connection.
Some of them did, some of them knew. I mean, it was like the rules committee. Same kind of people, serious lawyers from all parts of the state. You had to have all parts, well, you didn't have to have, but we did have all parts of the state.
Yeah.
And Marianne was one of the, we would nominate them, and then 3, and then they'd be selected either by the district judge or by a circuit judge.
Right.
That was a wonderful thing. The most fun I've had is the extracurricular stuff I've done that I didn't get paid for.
Well, you taught appellate advocacy at Vanderbilt in the 70s.
I taught several things very briefly.
Okay.
I taught the one I focused on the most was appellate advocacy. And one of the things that bothers me about law schools is they don't have much to do with the practice of law. There is not, to my knowledge, a single professor at Vanderbilt Law School that's ever tried a lawsuit. So they tend to be, I think, rather abstract, and they're not really very good. They're not like medical school where you have to go into an operating room, and they're abstract. And they talk about the majority rule. I've never met a judge that cared what the majority rule was, you know, that sort of thing. And when I taught appellate, I enjoyed teaching appellate advocacy. I had guest lawyers who I knew would be good come out and address the throng. And Dean Costonis was a dean then. I thought that the moot court wasn't worth anything if all you did was decide the case. So I thought the briefs should be specifically critiqued, and the argument should be critiqued. And I did that, but I had 50 students, and I was getting paid $500 for a term, which is all right with me. That wasn't a big deal, but I was getting paid about 15 cents a brief, you know, and it was wearing me out, and it's hard to do. If you do enough of them, they all read the same. I found that out at Harvard. You read 600 answers to a question, and your mind goes absolutely, you can't absorb what's being said anymore.
Yeah.
And I got a little bit of that in the moot court situation. And I went to Costonis, and I said, we need to break this up. You need to have 5 lawyers out here doing this and break this up so that each lawyer is just going over 10 briefs and talking to 10 students, and he can focus on it.
Sure.
And Costonis said, well, we can't afford that. And I said, well, I'm getting paid $500 a term. I'll waive my fee, and I'll tell you this, I'll get 5 other lawyers to do it for nothing. Never got done.
Didn't happen.
They just, it's kind of like they don't want real lawyers in there. I don't know what it is.
Yeah, yeah.
But anyway, that's when I left. I
Okay.
did it for 3 years, and then I just said, they're not serious about this.
Sure, sure.
So I left.
Well, who were some of the major influences on your legal career? And I'm really getting at this. This is real, but it's funny, but something that you've told me before. You start with Professor Eddie Morgan.
Yes.
Real law.
Yes.
Then Bill Willis. Real law.
Yes.
And then Judge Brown Taylor, who you spoke about earlier. Real law.
Yes.
And then District Court Judge Frank Gray. Be prepared to take it.
Yes. Yes. Well, the influences on my practice, as I said, Bill passed away in August, and as I said at that ceremony, he was the best teacher I ever had. In the early years of my practice, I would try cases as kind of his assistant, and he would always give me part of the case to handle, and his reactions to what I did were perfect. He wasn't overly critical, he wasn't nicey nice, he just kind of said, well, you might have done more of this, but you're getting better there. And so he was my best teacher. In terms of getting me credentials, Morgan was the absolute key because he recommended me for Harvard, and that put me in a good category for people who didn't know anything about me except that. And that was a good start, to say the least.
Yeah.
But I'd have to say Willis as a teacher. There's not much doubt about that.
Yeah, yeah. Well, then you had other non-lawyer influences, and one would have to be John Siegenthaler.
Oh, absolutely. John Siegenthaler was a great client, as you know.
Mm-hmm.
You represented him. And he discuss the issues with you. He didn't just say, "What should we do? Okay, we'll do it." He didn't say, "Oh, that's a bunch of nonsense." He was kind of like Willis. We talked it through, and he used me. That was when I started, back in the period when the Tennessean was really probably the most powerful political force in Tennessee, and they were really publishing some stories that had some danger.
Yeah.
And so we would discuss them pretty thoroughly, and I learned a lot about journalism, and he learned something about the practice of law. I met Al Gore, and you want to talk about a reporter that investigated. Good Lord. Well, Al, have you talked to him? Oh, yeah. I talked to his aunt.
We also got to meet a bunch of interesting people, one of whom you've told me about meeting Bobby Kennedy at Mr. Siegenthaler's house back in '68.
That was a very memorable, about 2 months before he was murdered. Bobby came to Nashville pretty early. Siegenthaler had been his administrative assistant.
That's right.
And right after he was appointed Attorney General. And Siegenthaler had Bobby out to his house just to talk to us. And it was a fascinating experience. It was, of course, after Jack was murdered. And Bobby was the coldest guy. He was running for president, and boy, he didn't slap anybody's back. I mean, he was going to tell you what he thought, and not mean, but just this is what I think. And way back then, this is kind of interesting in view of this year's political year. His whole crusade was jobs.
Yeah.
He said, what we've got to do is increase jobs. He said, you're talking about the civil rights movement. The greatest civil rights relief you can give is jobs. And he said, that's eventually what's going to make this a rational, good society, is being well employed. And he said it, and he said it, and he said it. And he was a tough guy, I'll tell you, but not mean, just he was,
Knew what
meant
he
what he
thought.
said.
Yeah, yeah.
And Merritt and I, of course, had it all worked out. Merritt was going to join Bobby's campaign and possibly pick fruit from a higher limb.
Yes.
And I was going to become the acting U.S. attorney, and Gil had already talked to the two judges about that. They would appoint me in that situation. And then Bobby got killed too, and
history changed.
Whole life
turned
upside down.
Yeah. Well, what were the rewards for you practicing law?
Well, I don't want to sound too namby-pamby, but I've always been pretty focused on the job. And what I like about the practice of law is helping somebody that needs help. And it's just that simple. Doing something I love doing. So that's kind of it. And anything that came after the fact, if somebody wanted to give me some award, that was wonderful, but I've never been a means to an end personality. I'm involved in what I do. I loved what I did, and sometimes I loved the result of what I did.
Well, speaking of awards, there are a couple of very significant awards you have been given. In 1985, the Society of Professional Journalism gave you the First Amendment Award, which is a significant award for your work in representing the newspaper and media law.
And representing the Society of Professional Journalists, Without fee.
Without fee. Now, in 1997, you were awarded the American Bar Association Silver Gavel Award.
Right.
And that is an award, well, it was based upon a book, your first published book, The Life of the Law.
That one right there.
And
I'm going to do like they do on television.
all right, well, here we go.
Oh, I've never seen anybody do that.
You're covering up the title. That award is given for a book, and you can say it better than I can, because that book was a perfect recipient for that award. It's for a book that helps the lay people understand the law without all the legalese stuff that we
Right.
lawyers use in our writing.
Right.
And you've written several books since then.
Yes, I have. They're all, no, 3 of them. 4 of them are decked out there. Yeah.
And you're still writing.
As the old saying go, enough about me. Let's talk about my book.
Well, Al, we could go on and on. If there's anything I haven't asked you you'd like to share with us, we'd like to hear it. And we certainly thank you very much for your time. And again, Alan McCall and Nashville Media Service, as if it's not obvious in the interest of disclosure, I met you in 1984 when you hired me as an associate and worked with you for all these years. So I had a little inside information that I think helped pull some nuggets out, I hope. And I hope people enjoy this.
You did a magnificent job of that. And I hope someday I get to interview you, because there are a lot of things I'd like to bring out about you.
Well, and we'll have to see about that.
Yeah.
Thank you very much.
Thank you.